Good, about you? This year.
Right, we'll go ahead and call the second day of our meeting to order, and we're going to continue with the agenda from yesterday. But before we begin, I'd like to acknowledge our court reporter, Lori Busick, and our hearing officer, Ms. Alexis Morris, our Attorney General representative. You have anything to say? So, Paul, you want to go ahead with?
Yes, ma'am. If you could, as far as before we do that, we exchange exhibits and the no objective, so we might offer other things. I'm offering those numbers MSB one, MSB 130. And I would, Jeff Moore, leading counsel, I'm going to continue with all of them. So please thank you.
Thank you, Paul. Yeah, my name is Jeff Moore. I represent Dr. Overton along with Brandon Party. We produce articles as well. These are GAA 001 through GAA 195. Dr. Overton. And I'm going to ask you to straighten it out.
Like to be entered at this time.
Well, you know what I'm saying.
It's on your.
Yeah. Yeah, I'm on it right now, so.
We're in the process of trying to stop killing the trees.
That's a lot of trees.
So we killed them anyway.
Those are your exhibits that we already have on this, I'm sure. I think we already have them.
Yeah, and I don't know if they.
Trees have been killed, so, yeah, you got them.
Trees dead.
The tree's already dead, so
That's right. Yes,
Thank you, sir.
we're moving towards.
Yes,
The day that you don't bring them, when we go digital, the Wi-Fi goes down and we can pull it up. You know, that's gonna happen. That's gonna happen.
Never played them, don't show it.
Right.
Yeah.
Yeah, it's all on the computer that you can install, but. Yeah.
And look who had it. She come in. You can, great stuff.
We're here today, this case, because Dr. Rosen was found, pled guilty to a misdemeanor crime involving healthcare fraud, federal fraud. The elements of that crime, which is from 42 USC section 1320 A-70, subparagraph A3. Whoever, title making a positive made false statement about this statement. It says whoever having knowledge of the occurrence of any event affecting A, his initial or continued right to any such benefit or payment, or B, the initial or continued right to any such benefit or payment of any other individual in whose behalf he is applied for or is receiving such benefit or payment, conceals or fails to disclose it with an intent fraudulent to secure such benefit or payment, either in a greater amount or quantity than is due, or when no such benefit or payment is offered. Break that down the way Judge Keith Sterrett did, where this was at the pleading sentence. The key to the statute of fraudulent. In his answer, Dr. Ozan has emphasized he is seeing the transcript, both the transcripts are in material, both the citizen transcript and the plea transcript. Dr. Ozan made an issue of the fact that he did not actively concede the information that should have been disclosed early on. That makes no difference. The key is he pled guilty to the crime, including the element fraudulent with intent fraudulent to obtain goods or services from the federal government to which he was not entitled, or an agreement. That's helpful. Now it is a misdemeanor. And I do want to backtrack a little bit, and I know that Mr. Morris will go over this, but Dr. Ozan was certainly not the only physician that was caught up in this these events. And Dr. Ozan was originally charged with 8 felony counts of healthcare fraud by the federal government. He went to trial, and the jury found him not guilty of 7 of the 8 charges. The jury hung, by my understanding, by 1 vote on the 8th charge. That 8th charge is still pending. There was a felony count. Dr. Ozan, and again, I don't want to try to make up things that Mr. Moore can correct me, but they reached a deal whereby Dr. Ozan would plead guilty to 1 misdemeanor count of healthcare fraud in order to end this. This started back in 2014. We went on for a year. And I believe the trial lasted something like 3 years. So it was a long way. But Judge Keith Sterrett, it's been a district judge in the state for many years, now senior judge, well respected, well known. Judge Sterrett absolutely knew what he had to find and what he had to do in order to legally accept the plea of guilty from Dr. Ozan. U.S. Court of Appeals for the Fifth Circuit, this is just an example. This happens. This is United States versus Jones. And I have the Lexus side, which is 2023 U.S. App Lexus 19559 75 F4. I'm sorry, just for a second, but F4 502. This is a criminal case in which person was attempting to appeal the guilty plea. The Fifth Circuit said, before entering a judgment on a guilty plea, the court must determine if there is a factual basis for the plea. This requires a district court taking a guilty plea to make certain that the factual conduct admitted by the defendant is sufficient as a matter of law to establish a violation of the statute. The transcripts make it clear that Judge Sterrett did everything. He went through every step. Federal judges, like all judges, they develop a routine in criminal cases where they've got kind of a checklist. Sometimes it's physical, sometimes it's just their head. And you've probably been there as long as Judge Sterrett, he probably has a criminal. But they just do every single step to make sure that they can legally accept the guilty plea. You'll see in the transcript, Judge Sterrett told Dr. Ozan, so make it clear, this is what the government must prove if you go to trial. And he read the elements of the crime. Judge Sterrett said, you understand that you are waiving all your rights to trial. You're waiving your rights. Anything else, you are admitting guilt. And I have to find that each of these elements has a factual basis before I can accept the plea. Dr. Ozan acknowledged that he had, and then he had to counsel. Judge Sterrett accepted before the judge. Judge Sterrett sentenced Dr. Ozan to 5 years of probation. He sentenced him to a $20,000 fine. Ordered him to pay restitution in the amount of $116,000. Dr. Ozan, as a matter of law, on a matter of his plea, is guilty of this crime. Now, I think the primary issue may be, what is a crime of moral turpitude? The statute makes it clear that there does not have to be a felony conviction, felony or misdemeanor, the crime involving moral turpitude. Moral turpitude is a term that's thrown around a lot, and it's not clearly defined that every little iota anywhere. It involves there's some discretion, but it's not limited. Moral turpitude involves crimes such as child abuse, sexual crimes that shock, the conscience. This is certainly not one of those. But it also involves crimes with elements of dishonesty or deceit. Crimes such as obtaining goods or services on false pretenses, embezzlement, money laundering. Crimes with elements of fraud are considered to be crimes of moral turpitude. Anything, evidence, dishonest. A person should not be placed in a position of trust. I think the law and the facts are clear. I think the others will show that. Obviously, Dr. Ozan and his attorneys may disagree, and I'm sure they're going to tell you that. But the statute that provides for a basis, a lawful basis for discipline of the doctor is being guilty of a felony ordinance for crime involving moral turpitude. The other charge, that's one charge that we formally brought in Dr. Ozan. The other charge is unprofessional conduct. Being guilty of any conduct. I apologize, I don't memorize it. Yes, sir. Like that I'm working on. Unprofessional conduct, which includes being guilty of any dishonorable or unethical conduct, like the healthcare fraud harms the public because it takes resources away that likely should be put elsewhere in the healthcare system. So this is a crime, a large crime against the federal government, but that includes, affects healthcare services provided. So that's our case. That's what we will prove. And I believe that when you review these documents, you'll find that those elements of what I've discussed are already proven in the document.
Good morning. Again, my name is Jeff Moore, along with Brandon McCarthy, who represent Dr. Ozan. I'm going to tell you a little bit more, give you a narrative of how we arrived here today. So Dr. Ozan, he's a 52-year-old physician practicing medicine in the Meridian, Mississippi area, who specializes in anesthesia, pain management, and hospice and palliative care. His primary focus is in pain management services and hospice and palliative care. Approximately 8 years ago, Dr. Ozan was interviewed by the OIG, the Office of Inspector General, and was told that he might be a witness in a government investigation related to compounded pain training. Approximately 4 years ago, in September of 2019, Dr. Ozan was indicted by the federal government and was accused of healthcare fraud related to a compounding pain cream scheme being conducted by a pharmacist known as Marco Moran. Mr. Moran was having pain cream prescriptions filled at various pharmacies by forging Dr. Ozan's signature on those prescriptions without Dr. Ozan's knowledge or consent. Marco Moran was found guilty of healthcare fraud and was sentenced to 10 years in prison. This is where he is now. Dr. Ozan was charged by the federal government with 8 separate criminal counts, ranging from conspiracy to commit healthcare fraud, wire fraud, and making false statements to a healthcare benefit program. A 12-person jury of Dr. Ozan's peers found him not guilty on 7 of those 8 counts. The jury was hung on count 8 by a vote of 11 not guilty and 1 guilty. The government, after tremendous and continued pressure by the judge, Judge Sterling, to resolve the case, decided to only charge Dr. Ozan with a lesser known misdemeanor for failing to disclose Marco Moran's illegal activities to federal authorities. Failure to disclose, nothing about concealment. Dr. Ozan did not conceal anything. Factual basis was modified at the plea hearing. Take out any reference to concealment because Dr. Ozan did not conceal anything from the federal government or anybody else. The evidence was clear and uncontroverted at his trial that Dr. Ozan did reveal Mr. Moran's illegal activity more than once, but not to federal authorities, not to TRICARE, not to the FBI, but he did disclose this information to others, including his employer at the time. At the time Marco Moran was involved in these criminal activities, Dr. Ozan was an employee of Rush Health System. Rush had a corporate compliance plan in place. It's like most major hospitals, major health systems, that compliance plans in place. I'm sure you're familiar with compliance. Dr. Ozan disclosed Marco Moran's activities to his supervisor at Rush Hospital, Karen Ford, in the pain management department at the hospital. Hospital employees, like Dr. Ozan, are trained to disclose suspicious activities to their employer under the health system corporate compliance plan. That's exactly what Dr. Ozan did in this case. Dr. Ozan also disclosed Mr. Moran's activities to Kathy Robinson, the corporate compliance officer at Rush Health System, to Tony Gore, another Rush supervisor at Rush Health System, as well as the pharmacies that were filling the prescriptions that had been forged by Marco Moran. He made disclosure to all those people and those entities. Dr. Ozan clearly disclosed the fraudulent activities of Marco Moran. There was never any attempt by Greg Ozan to conceal his knowledge of Marco Moran's illegal activities. So you ask yourself, why was Dr. Ozan charged with this misdemeanor by the government? The answer is that the government expected Dr. Ozan to go further with his disclosure, beyond telling his employer, beyond telling those pharmacists. The government expected Dr. Ozan to disclose this fraudulent activity being committed by Marco Moran to the FBI and to TRICARE, to the federal authorities. He didn't do that. Didn't know he needed to do that. Disclosed it to his employer under corporate compliance. Dr. Ozan thought he had met his obligation when he reported Mr. Moran's activity to Rush Health System and to the pharmacies that were receiving these invalid prescriptions. Would a reasonable person have known that they needed to report Mr. Moran's illegal activities to the FBI or TRICARE? Would you have known that? Or would they have thought it was reasonable to disclose Mr. Moran's illegal activities to their employer under their employer's corporate compliance plan, which is what employees of a health system are trained to do? That is how a corporate compliance plan works. So you are asking yourself, why did Dr. Ozan decide to plead guilty to this little known misdemeanor of failing to disclose another person's illegal activity? The plain and simple answer is that Dr. Ozan wanted his life back. Dr. Ozan wanted this whole matter to be over. mentally, emotionally, financially, he was drained. Dr. Ozan had been under investigation for at least 8 years when he first met with the OIG in 2016, and under indictment for 4 of those years. He had been beaten up by the government for 4 years of his life. Dr. Ozan had undergone a 2-week trial where he was literally fighting for his freedom every single day. Dr. Ozan was looking at serious prison time if he had been found guilty on any of these 8 counts. Dr. Ozan had spent approximately $2 million of his own dollars defending himself against these charges, 7 of which he was found not guilty on, and the 8 ended up in a hung jury. If Dr. Ozan went to trial on this misdemeanor charge, he would spend a couple more years involved in criminal litigation, 2 more years of his life, already spent 8 years fighting this. And he would have spent another small fortune in legal fees defending that case. Dr. Ozan wanted his life back, so he pled guilty to this misdemeanor to put an end to the chaos and anxiety that dominated his life for the past 4 years since he had been indicted. Dr. Ozan wanted to get back to a more normal life with his family and his work as a physician. You will also hear testimony today from one of Dr. Ozan's colleagues, Dr. Atim Murad, who will tell you that Dr. Ozan is a very well-respected physician in his community, and that his medical services are much needed in his community. We think that after you have heard all the evidence in this matter, you will reach the conclusion that Dr. Ozan did not plead guilty to a misdemeanor involving moral turpitude, and that Dr. Ozan is not guilty of unprofessional conduct, including any conduct that is unethical or is likely to deceive, defraud, or harm the public. He is only guilty of exactly what he pled to: failing to report another person's conduct to federal authorities. That's not helpful. After you hear all the evidence, we respectfully request that you reach a decision that Dr. Ozan is not guilty of the 2 counts that have been levied against him, that Dr. Ozan's medical license should not be suspended, and that Dr. Ozan has already been punished for them. Thank you very much.
When counsel calls Dr. Ozan, has to be sworn.
If there are any other witnesses, can we swear them in at one time, please? If you all would stand, and Madam Court Reporter, would you swear them in? Would you all like the ruling vote today?
Sure. Thanks. Good morning, Dr. Ozan. We met earlier when we called on, and I'd like to ask you some questions about guilty plea in criminal proceedings. You pled guilty to this misdemeanor crime maybe in March of this year. That's correct. Dr. Ozan, what is custom care pharmacy?
Custom Care Pharmacy was owned by an individual named Marco Moraine.
Do you have any interest in that?
I did.
$40,000.
Yes, sir.
So that's something we have heard yet, but the interest in the pharmacies, and my wife that that was the pharmacy that received some benefits that it shouldn't have received as a result of Mr. Moran's scheme.
Yes.
that what led, Judge Sterrett to require you to, repay $116,000?
Yes,
Judge Sterrett also fined you $20,000
yes,
since you 5 years probation.
yes.
And to be clear, it's obviously in the transcript. Judge Sterrett told you at the sentencing hearing that if you repay all the money, that you paid your fines, did, met all the other conditions in probation, that the court will entertain a motion to end your probation early after a minimum of 1 year. Is that right?
That's correct.
1 year has not expired.
Not quite.
That's why. So March 2022.
That's correct.
Dr. Bozan, at your change of plea, did Judge Sterrett explain to you the elements of the crime in which you were pleading?
He did.
And at your change of plea hearing, and perhaps the sentencing and vote, the government, strike that. At the change of plea hearing, the government presented what's called an information. Is that right? It was not an indictment, it was an information.
At some point, they presented that on them.
Well, I'll represent to you this transcript shows that they may have presented to you other times, but they presented it at the change of plea hearing. And in that information, which basically replaces the fact, there's a statement of the factual basis for a plea. You're familiar with that, right?
Yes.
And Judge Sterrett, after confirming that you had counsel, you received legal keep in mind that, right? And that you had legal advice.
Yes, I have legal advice.
And Judge Sterrett confirmed that you had discussed everything related to this plea deal with your company.
With one attorney, yes.
That was Tom Portner,
Um,
and he was your criminal attorney.
Lee one minute.
Mr. Portner was representing you at this plea deal.
Correct.
Okay. So, did Judge Sterrett give you a chance to take issue or correct anything that you felt was incorrect or wrong about the information you were pleading guilty to?
He did.
Okay. And what did you tell him?
I told him that the element of that charge about concealment, I didn't agree with, and he allowed me to explain that.
And I believe did you just talk about the fact that you did not actively conceal anything?
There was no differentiation between active and passive, especially with the denied decision.
Did you tell Judge Sterrett that you did not fail to disclose with an intent fraudulent to secure benefit payment to you?
I didn't even receive a single payment. So no, I did not conceal anything to receive a payment, so that is incorrect.
Okay, so if that's the case, are you going to return to federal court and inform the judge that the basis for the guilty plea is incorrect?
No, absolutely not. It's not what you asked me. I absolutely took responsibility for the guilty plea. That you asked me to change it, I might as well, yes, you allowed me to change it.
Right. You didn't change anything in the information that included the element about fraudulent.
If you refer to the last page of the factual basis, that is the corrections that were made, and it's completely written. So that's what we discussed.
Right. Well, the transcript reflects exactly what it said, exactly what it thought.
Right.
There's nothing in there about you not possessing fraudulent intent.
I had no fraudulent intent.
Okay, well, then if you didn't have fraudulent intent, did, strike that, did Judge Sterrett ask? He asked if you were guilty of the crime with which you were charged.
You did ask that question, yeah.
And what was your answer?
I initially said yes. And you allowed me to clarify.
And then after you've been told that, you testified that you didn't actively conceal information. And the whole thing, I mean, we can go through it, I've read it, it's in the record, where I had to read it all, word for word. After that, did Judge Sterrett say anything like, oh, well, that changes everything? Or I understand that this means this totally changes the intent. He didn't do it.
Judge Sterrett asked me, did I disagree with any element of the charge where I told him I did, and I explained to him what I disagreed with. And my attorneys and the U.S. attorney agreed with it.
Right. And Judge Sterrett told you, you read the elements of the crime to you. You made it absolutely clear that by pleading guilty, you were admitting that there was a factual basis for each and every required element of this crime. Did you not?
That's incorrect.
Why is that incorrect?
We didn't discuss, that's not how the discussion went.
I'm sorry.
You asked me the question and I answered that.
No, I didn't understand. I didn't.
Oh, I'm sorry.
I'm sorry.
I said I answered that question.
Well, I just want to make sure that I'm not spending time on things that don't matter. I've asked, I believe, Ms. Reed, Judge Sterrett, explain the elements of the offense scheme. Is that correct?
I've asked that internet, yes.
I object. I have closed my argument. I believe in this state's the law. And it's inappropriate at this time. It's a speaking of death or anyone else. It's not a problem.
Actually gonna strike that from the record. You can continue.
Okay, I'm on MSB 83. Sorry. See the numbers in the bottom, like in the identification of we have defined page 83. And just so it's clear what the looking at, let's back up to page 70. Trying to get you. All right, in the title page, this is a criminal case against you, correct? Good. And it's entitled transcript of change of plea proceedings Monday, March 20th, 2023, before the Honorable Chief Sterrett, United States Senior District Judge, correct? Correct. Now, if you turn to page 83, I'm referring to the numbers in the bottom right hand corner. Anyone's looking at the top right hand corner, page 13, the transcript. On line 15. Before I can accept your, going back up. Line 10. The court is informed that you wish to change the previously entered plea not guilty to the plea of guilty as to count and bill of information. Is that correct? Then, yes, sir. 4. Before I can accept your guilty plea, I must be sure that in fact your plea is in fact a valid plea and that you are in fact guilty. In order to do this, I will need to ask you a number of questions. Answers to these questions must be truthful. Accordingly, I'm going to ask the clerk to place you in the oath. If you please raise your right hand and pledge allegiance to the oath. You were sworn, correct? Judge Starrett, then over the next several pages, ask you questions about you generally. And on page 86, specifically ask about your competency to ensure that you are competent, mentally competent to make a legal plea. You see that, and I'm not quoting. You recall that, you see it on the transcript. Yes. On page 17, on page 17, Judge Starrett is continuing the statement from the previous page. Referring to you, he says, he appears here today to be alert, responsive. He's obviously understood all the questions and answered them intelligently. He does not question his competence. Neither does his attorney nor does his attorney. Accordingly, the court finds Dr. Ozan is competent here today for the purpose of entering a guilty plea and is competent during the relevant period charged with the information. The law requires that you be adequately represented by your attorney. That you had ample opportunity to discuss this case with your attorney. Your answer is, I have. That's correct. All right. Correct. Page 18. Judge Sherry asked you about your right to a jury trial. Is that right? Did you tell Judge Sherry that you understood that you were waiving your right to a jury trial? Yes. On line 10, I am paraphrasing, and I'm not sure that he asked you that you understood that the trial would be presumed innocent or not guilty, and that the government would be required to prove you guilty by competent evidence beyond a reasonable doubt before the jury could be authorized to find you guilty, and then you would not have to prove your innocence. Answer, yes, you are. Did I read that correctly? You read it correctly. He then asked you several other questions about the way a trial would proceed and your rights. On page 19, line 20, Judge Starrett says, before I will accept you guilty plea, I must be convinced that you are, in fact, guilty. I will require that you admit you're guilty. If you do this, you will be waiving or giving up your right to remain silent. That is, your right to not testify against yourself. You understand that? Answer, yes, Your Honor. Is it still your desire to waive your right to a trial, the right to a trial, the right to remain silent, as well as these other rights that we've been discussing here this morning and enter a guilty plea here today? Answer, yes, Your Honor. Question, it's my duty to explain to you the nature of the charge that you're pleading guilty to, and as set forth in the Bill of Information, the maximum possible sentence that the court can impose upon you if the court accepts your guilty plea. I'm sure that you've received a copy of your Bill of Information. Yes, sir, I have. Have you gone over the Bill of Information with your attorneys as well as any defenses you may have to the Bill of Information? Yes, sir. All right, yes, sir. The Bill of Information charges you as follows. Title 42, United States Code, makes it a crime for anyone having knowledge of the occurrence of any event affecting A, with initial or continued right for benefit or payment under a federal health care program, or B, the initial or continued right to any such benefit or payment of any other individual in whose behalf he is applied for or is receiving such benefit or payment, conceals or fails to disclose such a thing with an intent to fraudulently secure such benefit or payment, either in a greater amount or quantity than is due or when no such benefit or payment is authorized. You're charged in count 1 of the Bill of Information with fraudulent failure to disclose, which is set forth in the code section I just read. Now, to be guilty of this crime, Government must prove each of the following elements beyond a reasonable doubt. First, that you have knowledge of the occurrence of an event affecting the initial or continuing right of payment under a federal health care program or of any other individual or entity, or of any other individual or entity on whose behalf is applied for is receiving such benefit or payment. Second, that you conceal or fail to disclose such event. Third, that you did so with the intent to fraudulently secure such payment when no such payment is authorized. And fourth, that the application for payment was by another person. If the court accepts your guilty plea, the court can sentence you to a sentence of not more than 1 year of imprisonment, not more than a fine of $20,000, not more than 1 year of supervised release, and a special assessment of $100. Now, I'm not going to read page 22. It's in the record. Judge Garrett goes through further terms of this sentence. On page 23, line 7. Do you have any questions, Dr. Ozan, of what the government would have to prove you guilty of, the charge, label, bill of information, or any of the sanctions that the court could impose if the court accepts your plea of guilty? Answer: no, Your Honor. Ms. Porter is referring to the government's attorney, if I understand. Did the government previously make a plea bargain offer this defendant? Ms. Porter: yes, Your Honor. The court: do not tell me the terms of the plea offer. The court is not involved in the plea bargaining process. I'll ask this to Mr. Porter. Did you fully discuss with the client the terms of the offer made by the government, Mr. Porter? Mr. Porter answered, I did, Your Honor. Fourth, did you give your client your best advice about this offer, about the pros and cons of pleading guilty or proceeding to trial consistent with your professional responsibility? Mr. Porter: I did, Your Honor. Then on line 6 through 15, Judge Garrett asked you about whether you were satisfied with your attorney's advice. He asked some questions of the attorney. And on page 25, line 2, I'm sorry, 25 of the transcript, 95. I apologize, I realized it. On line 2, Judge Garrett asked you, has anyone threatened you or forced you or in any other way coerced you to come here today for the purpose of entering a guilty plea? Answer: no, Your Honor. Are you voluntarily entering this plea of guilty? Answer: yes, Your Honor. Question: I understand that a plea agreement and plea supplement that I'm going to hereinafter going to refer to as a plea agreement, I'm going to refer to them as the plea agreement, has been entered, and these documents have been entered into between the parties. Is that correct, Dr. Roseanne? Answer: yes, Your Honor. We then ask the attorney. Government's attorney. On line 19, the government's attorney, actually, I believe this is the court. This Porter, the next several pages of the transcript are the government's attorney. On page 98, MSP 98, line 9. Judge Garrett asked you, Dr. Ozan, do you have the plea agreement before you? Answer: yes, Your Honor. Question: have you read it and discussed it with your attorney? Answer: yes, Your Honor. Question: have you signed it? Answer: I've signed it, yes, Your Honor. Question: all right, has anyone made any promise to you or any side agreement which is not stated in the plea agreement? Answer: no, Your Honor. Question: he asked you the plea agreement. I'm paraphrasing, you said yes. Then Judge Garrett makes comments about the attorneys. I believe using fewer words than you normally agree. Thank you. I apologize. Thank you. Good day. on, page 100. Page, line 21. The spirit says, yes, sir, and if you want to present any other, you mentioned something about maybe your wife testifying, and you also, and I'm also gonna give you the right of allocution, speaking allocution. That's not ever gonna be taken away from you. But I just want to make sure that there's no problem. Ken has no problem with waiving the pre-sentence investigation report. Talk to your attorney, let him discuss this with you. Mr. Porter, thank you, Judge. Dr. Ozan, he's ready to proceed. He doesn't object to the waiver we received for the pre-sentence investigation. He's aware of his rights to do so. He wishes to proceed. Porter, is that correct, Dr. Ozan? Answer yes. On page 102, transcript page 32, beginning on line 10, Judge Derrick says, I'm now going to determine the factual basis for the plea. Then ask this Porter, the assistant U.S. attorney, to state to the court the facts, the basic facts the government would expect to be able to prove if your case were to go to trial. I want you to listen carefully to her, because when she's finished, I'm going to ask you if there's anything that she said that's incorrect. Okay, then Ms. Porter proceeds on page 32 and 33 of the transcript. Apologize. So you get to page MSB 107. As Ms. Porter finishes, Judge Starrett asked, Dr. Ozan, do you agree with what the government's attorney has related to the court? Who is in fact what happened? Mr. Portman, your attorney says, may I have just a minute of my time? Court says yes. This is a short break while counsel can go ahead. I think the key point is, he talks about the time frame on page 108, beginning on line 14. So, this is your attorney. So, and the other thing that we have a little bit of difficulty with, I want to point out to the court, is there is a sort of assumption, a presumption, I think, that my client, by pleading guilty to something, says he concealed information, that he actively concealed information. What we believe the facts support is he failed to report to the appropriate entity what was discovered, but he didn't. I don't think his actions show that he's not admitting that he's actively concealed. If concealed, as is contained in this information, means a passive failure to report. Report. What you're saying is you reported to this court, but not to the agencies with the cover. Mr. Porter, that's right. The defendant, that's correct. Mr. Porter, that is absolutely correct. The court. And that's the only part of the facts, factual basis that you're objecting to. Mr. Porter, yes. Yeah, I think that's correct, Your Honor. All right. And then talk to the government's attorney. Ask whether the government's attorney basically is in agreement to modify the information. There's then some discussion on page 110, 111 about whether or not your $40,000 investment, whether that was in fact buying a percentage of your business of the pharmacy or whether it was a loan. And it includes in that discussion, your attorney withdrew any objections to the portion of your information that stated that you owned an interest in the funds. Is that right? Good. And that's true. Is that true? Of course it is. Is it true that you own a $40,000 stake in Custom Care Farms? Yes. Page 111. All right, is there anything else that this order has said that you disagree with, Dr. Cody? No, Your Honor. Now, how do you now plead to the charge? Guilty or not guilty? Guilty. Report. The finding report in the case of United States versus Gregory Alden, Ozan MD, that the defendant is fully competent and capable of entering an informed plea, that the defendant is aware of the nature of the charge and the consequences of the plea, and that the plea of guilty is a knowing and voluntary plea supported by an independent basis in fact, containing each of the essential elements of the offense. The plea is therefore accepted, and the defendant is now adjudged guilty of the offense set forth in the bill of information. Did I read that correctly? Yes. Is that your recollection of the events? Yes. You know anything about the federal law governing restitution and a healthcare fraud case? No. So you're not aware that in order to award or restitution, require restitution, the court has to find the criminal conduct of the defendant, in this case you, caused the law for which restitution is given. In other words, under the restitution law, we can get the statute out.
Okay, that's fine.
Okay. Do
Wait
you
a
know
minute.
why? Oh, sorry.
I'm gonna sustain your objection.
Do you know why Judge Sterrett ordered you to pay restitution in the amount of $116,000? No. No. Judge Sterrett ordered you to pay $116,000 in restitution.
And especially the restitution was decided between my attorneys and the U.S. attorneys, not Judge Sterrett. Sorry.
We'll cover that in later. So, other than the discussion about whether you actively conceal the information, is there anything else that you told Judge Sterrett at the plea, during the plea hearing, that you disagreed with about the information that the government presented? No. Have you in fact paid the restitution ordered by the court? No. You paid the fine, the other miscellaneous charge. Okay. And I get. It is my understanding that would therefore make you eligible after 1 year to go back to the board and ask for probation. Does that also your understanding? You're aware that a hearing is required.
I'm not sure I'll rule.
Okay. But we have moments of that. So, as you sit here today, are you telling this board that when you agree that there was fraudulent intent in connection with these events, that you were talking about Mr. Moran, not yourself?
I have never committed healthcare fraud, ever.
Did you plead guilty to this crime under 1320A-7B83?
I didn't. I've never committed healthcare fraud.
What is your basis for your belief that this is not healthcare?
There's no belief. I've never committed healthcare fraud.
Excuse me, Dr. Ozan, plead guilty to this crime, correct? The crime in this statute.
Yes.
Did you? I asked this already and I'm repeating myself, I apologize. Did you tell Judge Sterry that the only fraudulent intent involved in your plea deal is Mr. Moran's fraudulent intent, not your own?
I have no fraudulent intent. You know, and did not commit healthcare fraud in any way.
I apologize for speaking over you. My question was, did you tell Judge Sterry that he would plea or sentence to this
I don't recall that conversation.
transcript? And so you don't recall it. Do you think you did? Tell Judge
I'm not
Sterry.
gonna guess. I'm not gonna guess. I don't recall.
Okay. Do you have any other witnesses at this time? Would
Does
you
the
like
board
to-
have any, I don't have any more questions.
Okay.
Before I listen.
Absolutely.
Board have any-
The board have any questions?
Any questions right now? No?
I'm not sure if it's proper to ask you, but, you were found innocent of 7 of the 8 counts by the jury, is that correct?
Yes, sir. 12 votes for not guilty. It's no guilty votes 7 times.
And on the 8th charge, this was the charge of, that we're talking about here. The jury was hung 11-1.
That's correct.
That's not the charge.
Will you stand up and come to the microphone, please, for clarification?
Yeah,
Thank you.
so just for clarification, that 8th count that you're talking about, that's not the charge that Paul Lawrence has been asking y'all for those anything. They did not retry him on that 8th count. That count had something to do with providing information to a healthcare benefit program. So the government came back and charged him with a lower level misdemeanor, which is what we're talking about.
Well, can I ask, was it 11-1 innocent? I mean, 11 for innocent and 1 guilty?
Yes, on the 8th count, on that 8th count. So if it would have been, if whether there'd have been one more vote, he'd have been acquitted on all 8 counts and we wouldn't be here.
Okay, that was what I was asking. Thank you.
Thank you. Does the board members have any other questions? Okay, Paul, do you have any reader?
I have no further questions, but in response to what counsel has said, in fact, the charge I've been referring to was not the 8th charge, the felony count. But if you look in the exhibits on page 126, that's the statute, the crime that Dr. Hosen was guilty to. You'll see that down in the bottom paragraph, it states that this crime could be either a felony or a misdemeanor. I have no further questions.
You may step down at this time. Unless he's going to be your, if you don't have any other witnesses,
Complaint counsel.
it's like that's risk. Is he going to be your first witness, counsel, or would you like to?
Thank you. No, he's not gonna be our first witness.
Okay.
I believe, we brought, our first witness.
Okay. Thank you, doctor.
Mr. Cliff, can you introduce yourself?
My name is Robert Smith. I'm a partner at Catton Nation Roseman in Washington.
And just for the record, you were this morning, the court reporter over here,
Yes,
you said yes,
I did.
you're telling the truth. Can you tell us a little bit about yourself, so we know who you are, kind of your background?
Sure, I'm a lawyer. I graduated Georgetown Law School in 2005, and I moved to Raleigh. I clerked for the chief judge of the U.S. Court of Appeals for the Second Circuit, which is the federal court of appeals with jurisdiction over New York, Connecticut, and Vermont. So we heard basically all appeals that came up through the New York federal system. Worked for 2 years at Jones Day in their appellate practice. I joined a white collar criminal defense firm in New York for a year, and then eventually came to Catton Nation Roseman in 2010, where I've been ever since.
So how long have you tried?
If you include the clerkship, nearly 20 years.
And as far as like specialization, from gathering this morning, you just said, what do you specialize in?
We don't say specialization, right? Because the state bar doesn't like that. But what we say is that we have a focus as lawyers. My focus is on appeals and critical motions and trial court. So I am a legal guy on trial teams and I can do
Like the minutia of the law, kind of the nitty gritty of statutes, appeals,
that's correct.
and what was your role in this particular thing?
So in this case, I assisted the trial team when Dr. Ozan was charged with the 8 felony counts, providing legal support, legal analysis. I became heavily involved in the case after the jury returned its verdicts of not guilty on 7 counts and the hung jury on the 1 count. And then after, I guess, becoming more involved, I then took over negotiations of Dr. Ozan's plea deal with the Department of Justice.
With respect to the doctor's question about 11-1 not guilty, they reduced it down to this year. They ultimately dismissed the 8 count.
That's correct. So I think an overview would be useful. Dr. Ozan on the 7 counts was charged essentially for actively participating in Mr. Moran's fraud. So the government accused him of being an active participant in that fraud. The 8th count was his failure to disclose his active participation in that fraud to a federal healthcare program, in this case, PCUS. The jury acquitted him of active involvement in Marco Moran's fraud, and it hung 11-1, 11 not guilty votes, 1 guilty vote on whether or not he failed to disclose his participation.
And as far as the plea negotiations, it's fair to say that you're dealing directly with the federal prosecutor in this current office. We all decided that how to call it.
That's correct. There were 2 prosecutors that I dealt with on a regular basis from the Department of Justice that were the trial lawyers that handled the case, and we had regular communications and oral discussions over the plea resolution.
And just to be clear for the record, as far as the fraud, that's exactly what Dr. Ozan is found not guilty of. I always do. Also,
Microphone.
Paul, they can hear you. Sorry, that's okay.
I object because I want to clear for the record whether this witness is being offered as some sort of a legal expert witness or he's testifying fact witness, because it makes a difference as to what testimony he can give you.
Counsel.
The 2 are intertwined. Yes, factual knowledge, because we dealt directly with respect to the prosecutors and negotiations raised actually by the charge. And of course, Mr. Barnes put the elements that is the legal aspect of the charge into question during the question of Dr. Ozan, as well as his oath. So we are now rebutting that factually and legally based on what he raised.
As to your first objection, I'm actually going to sustain that objection with the line of questioning towards the witness. The second objection regarding whether or not he's a factual witness is overruled.
What about my objection as to
He hasn't really asked an expert opinion. He was actually the attorney that handled the plea, so I think he has firsthand knowledge, of it. Thank you.
For clarity, Mr. Barnes referred to the Fifth Circuit appeal, you actually came about entire thing, correct?
Yes, so after Dr. Ozan was acquitted on the 7 counts and the jury hung on the 8th count, we were permitted to bring what lawyers call an interlocutory appeal. That is an immediate appeal to the Fifth Circuit, in which we argued that as a facial matter, Dr. Ozan could not be recharged on that 8th count because it would violate his rights under the federal judgment clause.
Let me move back to the misdemeanor. I want for clarity, we have an affidavit which called from the board to MSD 006, Brett Estes. We've been able to listen to board that. No, exactly.
Yes, I have any
In it, and true that he basically says, or states that Dr. Van essentially is found guilty of, and he says, conceal and fail to disclose such events. In there, correct?
That's what it says, yes.
No offense to David, Mr. Estes, but that was before the transfer came out, correct?
I am not sure,
And Mr. Estes, you're not, was he at the hearing?
not to my knowledge.
And is that affidavit basically concealment? Correct.
No, it is not. I think I understand why it was stated in this way.
And why do you think that?
So when the law charges, and this is fact, and I'll explain my basis for it. When a law charges alternative ways in which a defendant can be convicted of a crime, the federal criminal guidelines, it's called the Criminal Resource Manual, it's section 227, instructs federal prosecutors to charge in the conjunctive, to use an and, to keep all options open to them. But Dr. Ozan only pled guilty or offered a factual basis for non-disclosure.
And with respect to that element, is it true or not true that it was struck by the judge, Judge Terry, from the guilty plea, or was it included?
Do you have an objection, counsel?
I felt transfer.
Based on the transcript and also the factual basis, as I understand it, Dr. Ozan only agreed to facts that he failed to disclose, not that he concealed.
In fact, specifically, Commissioner Barney's exhibit instead of MSD 045. Mr. Barnes did, additionally, but he failed to read the factual basis of the plea to the panel. Correct?
That's correct.
Okay, and you have that in front of you?
I have a portion of it in front of me here. I think I can explain this in context of what happened at the hearing. So Judge Scarrett is under an obligation to make sure that there is a factual basis for the charge in which Dr. Ozan pled guilty. He recited the elements. After that, the prosecutor's responsibility was to read into the record the factual basis that Dr. Ozan and the government agreed the facts that supported the charge. That was read into the record. The key aspects of that factual basis read into the record are at MSP 39 through 40. That's where essentially the prosecutor says what all parties agreed Dr. Ozan did. And if you'll notice, it's beginning at line 14. This is on page 36 of the transcript, MSP 39, and continuing to the next page to line 4. Dr. Ozan never admits to having a fraudulent intent on his part. The factual basis says, for example, as a result of the fraudulent prescriptions that Moran submitted and that the defendant failed to disclose. So that's on MSP 40, lines 1 through 2. And then is to finish my question, my answer. After that, Judge Sterrett understood that this was the factual basis and accepted it.
So procedurally, I told this thing, so you got the judge required to read the elements. Like, essentially script, read the elements, you ask the defense sort of questions on this going, right?
That's my understanding.
And part two is you get into the factual basis of the plea and the factual record. That's how it works, right?
Yes,
And that is what we see explaining the case on MSP 045 and all that. Is that right?
yes. The factual basis here is also recounted in the record at MSP 00045 through 46. I was reading from the transcript where that was actually read in at the change of plea hearing, and that's at MSP 39 through 40.
That's the part where it talks about, we're going to Moran Smith, and the defendant failed to disclose, result of this $116,000 loss.
That's correct.
It's actually, if we're looking at the dates, the charge goes from March 2014, so 9 years ago, to May 2014, right?
Yes,
And according to the document, that was Judge Sterrett, he didn't discover it until May of
Yeah.
2014.
yes,
And according to the testimony of the church in the record, that you did not reveal it in May of 2014, the three administrators and forms.
that is my understanding. Yes,
This is more of a common sense question. Wouldn't that make it impossible for him to have fraudulent intent if you revealed it immediately from May or something that happened before?
Objection. That is question that the next one is also.
Any rebuttal, counsel?
That's why I phrased it as common sense. Has he committed an offense before he discovered it?
Which involves the body.
I'll move on.
I'm going to sustain it.
All right, and just so we're clear on the record, he tells a bunch of administrators, he tells the farm stand sitting behind, who does he not tell before his basis? This charge, this misdemeanor charge.
TRICARE and or federal law enforcement.
And again, if you, as an appellant, you're 20 years experience, you research these issues, this certain elements, you didn't prove it.
What I will say is that in the law, it is rare to impose an affirmative duty on somebody to disclose something else. Somebody else's commission of offense. And my understanding of this statute was that Dr. Ozan's duty arose simply by virtue of the fact that at the time he had an ownership interest in or a financial interest in Custom Care Pharmacy. So by basis of that financial interest, this statute imposed a duty on him to disclose to law enforcement.
In respect to Mr. Barr's question, that did you talk to counsel about whether this would affect your license, that kind of thing?
Yes,
You said he was sued by counsel, that is you on this issue, is that right?
that's correct. We researched this statute carefully. I was unaware of any other case, frankly, in which this statute was ever charged under. And we could not find a single example of an adverse action taken by a medical board in any jurisdiction of the United States based on the statute.
So he's testifying as a legal expert based on his legal research about an issue. That's improper unless you can operate as a legal expert. He has not been tendered as a legal expert. He was disclosed.
I can form a basis of the knowledge as to this question. I guess that is my point.
Overruled.
With respect to this issue with Mr. Barnes, great. And his testimony and presentation, what did you said what did you, and who's we, number one, and what did you all do in order to address this specific issue that you want to raise?
Myself, another partner at my law firm, 2 associates, and a paralegal conducted research using Westlaw to determine whether or not any adverse licensing action was reported with respect to this statute.
Did you do the same thing with respect to Mr. Barnes issue you raised against the common carrier?
Yes, that would have been encapsulated in our research. We were looking for any adverse action taken against a doctor based on this federal misdemeanor that Dr. Ozan pled guilty to.
Just an idea of the extent of research that we've done on this commission for everyone.
Westlaw is a comprehensive database of reported legal and administrative decisions. So anything that was reported to Westlaw should have shown up in our search. We researched the statute carefully and could not find a single reported example of a medical licensing board taking an adverse action against the doctor based on the statute.
Breaking that down one by one, in direct rebuttal to Mr. Barney's contention about this being a common man privacy, we tell the panel how many times has this statute ever been categorized as common man privacy in the United States of America?
We could find no examples.
And how many times has this statute, in fact, this statute ever been used to sanction or suspend a doctor in the United States of America? Ever?
We could find no examples.
You feel that you did a sufficient job, you and your team did a sufficient job researching, digging into this, and looking.
Yes, that's my job, and I exercised extreme caution in my research.
And with respect to you doing the plea negotiation, the fact that Dr. Zane didn't know he was called tricarial downstairs, does that matter under opinion? Does ignorance of the law, does that matter?
No, the fact that Dr. Ozan had a legal duty meant that even if he was ignorant of that legal duty, he was guilty of the offense. And so that's why there was a sufficient factual basis for Dr. Ozan to plead guilty to the crime and for the court to accept it.
And when you did the negotiation and you're recommending you take this plea at any time, did you believe an attorney that you was agreeing that he committed for a fee that Dr. Ozan committed?
That was not my understanding of the statute. We read it carefully. It's admittedly a convoluted statute. I think Congress could be more clear. We specifically discussed the issue with the Department of Justice, and there's a reason why the factual basis and the key that I recited, which I think is on page, again, I'll go back, but it's on 39 through 40, does not represent that Dr. Ozan himself had fraudulent intent, because we did not believe that Dr. Ozan could be guilty if it were his fraudulent intent.
Objection, I didn't know the council.
Why we have to.
This is slogan, thanks for the stuff.
Sustain.
If I may,
You cannot, thank you.
With respect to the $116,000 restitution, rate, please tell the panel how much of $116,000 Dr. Ozan ever received. If you know, from the facts.
Dr. Ozan did not receive any penny, as I understand it factually, from Marco Moran's fraud. Marco Moran committed that fraud and Marco Moran profited from it. So the restitution award that has been recited by counsel for the board was not money that Dr. Ozan derived at all from Marco Moran's fraud.
If you could explain, this point brought up the issue. It says when you recite some things fraud, explain why does it say that and read like that? You now testifying that doesn't apply to Dr. Ozan.
Again, and I want to be clear as to the basis of my discussions here, because I would never waive attorney-client privilege. I am talking about negotiations that I had with the Department of Justice. So these are statements that I made to the DOJ attorneys when we were negotiating. Part of what we discussed was the fact that Dr. Ozan did not commit healthcare fraud, and it was not his fraud, it was Marco Moran's.
Let's just say I appreciate clarification and withdrawing.
Some context. This failure to report someone else's fraud, happened, how long?
My understanding of the relevant period is March to May 2014, so over 9 years ago.
Right. And with respect to not reporting, someone else's fraud, not your own. You did extensive research when you look at that situation.
The issue of, I'm sorry, you mean,
Well,
it's very good question.
legally, is there something called misprision in law?
Yes, but my understanding is there is a concept called misprision.
And just so we understand, this prison, for an example, probably from off base. Let's say, I think Mr. Barnes here to the bank to withdraw some money. And he goes there and robs the bank. Shoots the bar, comes out and tells him. If
I'm gonna go ahead and get the question already, but it's hypothetical.
Microphone, you want to talk over this?
Yes, sir, I apologize. The basis of the question so far establishes that it is a hypothetical question. It is being asked, he's asking for an expert legal opinion regarding the prison of a felon, which is not a charge that was ever made in this case. That crime is not relevant. And this question is improper and irrelevant.
He's raised on felony, it's a misprision misdemeanor. Which is where we are. He raised it, that's how it's going.
Sustained.
So 9.5 years ago, this failure happened. Are you aware, factually, are you aware of any misconduct by Dr. Roseanne in the past 9.5 years? That, or any,
No, I'm aware of no accusations of misconduct against Dr. Roseanne. And part of my basis for that opinion is that we did extensive research leading up to Dr. Roseanne's sentencing in this matter, and there were no other accusations against Dr. Roseanne.
in fact, has he ever had a problem with the board? Absolutely.
My knowledge, no.
And he, just to be clear, has he been practicing law? I mean, hopefully not. Practicing medicine. Practicing medicine, the fact this consistent 9.5 years since this whole saga began.
Yes, my understanding is that he has been practicing medicine during this entire time period, and I would specifically note that Judge Sterrett commended him for maintaining his practice while he was under the felony charges.
I was gonna have the, I'm sure Mr. Barnes quoted Judge Sterrett several times. But if you familiarize yourself with the final sentencing transcript,
I have.
and based on what you've read, did, again, black and white, what he says, did Judge Sterrett, been doing this forever, endorse or not endorse the continued practice of medicine by Dr. Roseanne? And tell me why or why you disagree. I don't want to.
I checked, that's this opinion, what the judge in the transcript itself is advocate. For Dr. Roseanne, his interpretation of the transcript of the subclass of the witness, that is involved.
Let me ask you this from Mr. Barnes exhibit MFU 031. When the judge says to Dr. Roseanne, your reputation in Lauderdale County, your testimony was that it was very good. Would you take that as an endorsement or not endorsement, continuing to practice medicine?
I'm sorry, which page are you on?
MSU 034.
And I would interpret that as an endorsement. Judge Sterrett factually during the hearing said a number of complimentary things about Dr. Roseanne. He said that the way he conducted himself during the trial, maintaining his practice and maintaining his family was admirable. Those were his words.
Did you
He
also
said
say
that Dr. Roseanne had a good reputation in the community and is a good doctor. And as I understand it, he said that his patients need him. Judge Sterrett had the discretion under the law as a misdemeanor to sentence Dr. Ozan to up to a year in jail. He imposed a no jail sentence on Dr. Ozan, which would permit him to continue to practice medicine if he's licensed to do so.
So is it fair to say, based on your testimony, that there's no legal precedent in the United States requiring a physical contact?
Objection. He is not testified to that. He is not been asked about what constitutes private medical.
Sustain.
Did you research Mississippi law of all the other 49 states?
Yes,
Is there any precedent in Mississippi or the other 49 states for doctor being suspended? Your team could find. Respectable statute.
you could find no precedent.
No money received, 116,000, right?
That's correct.
No infractions other than 1 year, 20 years. Before you do it.
That's my understanding of this.
And as you stated, one that I did, and your family, that was dead 30 years. I don't think about that. We're in the same.
That's correct.
Storms, are you ready to proceed? Okay, before you proceed, are the board members okay? Do y'all need a break? Or are you okay to proceed? We need to go. Okay. You ready?
What state do you guys?
Licensed in New York, Maryland, and District of Columbia.
You are not only making the appearance of a wrong review, you're just on.
That's correct.
What's the applicable restitution statute under which Judge Sterrett ordered Dr. Ozan to pay $116,000 restitution?
There is a federal statute in the criminal code that governs restitution. I do not have the section memorized.
That's why we may have to take a break, because I was researching on my phone, but I'm looking in the transcript. Because it's Friday. But you're familiar with that statute, are you not?
Yes, I'm familiar with the restitution statute and researched it as part of the negotiations and had specific discussions with the Department of Justice about the basis for restitution in this case.
But in the transcript, Judge Sterrett says that nothing that regard between the attorneys outside this hearing that in effect can be interpreted the statute. I mean, the transcript.
I don't understand the question. Yes.
Judge Sterrett says there aren't any side deals. There's no other agreements between the parties. The court has no role in legal.
Yes, that's correct. I can only testify as to my understanding of the basis for restitution in this case.
Understood. But Judge Sterrett, was he directly involved in those discussions? And I don't know. Was there may have been conflict.
No, federal judges traditionally do not get involved in plea negotiations. Judge Sterrett's knowledge of the case and facts would have been derived from the factual basis that we spoke about, that I spoke about earlier.
Okay. Thank you. Now, several times in your testimony, just extensive legal research, correct?
Yes,
Have you ever performed extensive legal research on an issue only to lose on that issue on the appeal?
certainly, yes.
right? And counsel asked you about the double jeopardy issue that you raised in the appeal to the circuit on Dr. Ozan's behalf on an interlocutory appeal, correct?
Yes.
What was the outcome of that appeal?
The outcome of that appeal was that the circuit ruled that the trial could go forward on the 8th count. It ultimately did not. But the 8th Circuit specifically held that in the trial, Dr. Ozan could raise his double jeopardy defense, and that the district court may determine that the jury would be precluded from hearing evidence or argument that Dr. Ozan was an active participant in Marco Moran's fraudulent scheme.
You lost that appeal.
It was a remand, yes. They affirmed the decision that facially the charges could go forward, but the opinion specifically says that at the retrial, Dr. Ozan would raise his double jeopardy.
There's another thing I want to ask about that Fifth Circuit opinion. I'll get it out of my office when we have the next play. I'm looking at page MSB 62. Do you have that?
Yes, I have it here.
Okay. I believe that these may just be excerpts, you know, I'm not sure. If they aren't line numbers, it's probably, I guess I think it's a rough draft, but Council Bob, we agree that they do not have to be certified copies. In the middle of the page, third and fourth paragraph, in accordance with 18 United States Code section 3663A, defendant shall pay restitution, which is mandatory in the amount of $116,000 and some odd cents. So 18 USC 3663A is actually the provision that sheriff is relying on for the restitution, correct?
Yes.
Under 3663A, does the victim receiving restitution, like for whom restitution is ordered, not have to be directly, approximately cause injury by the conduct of the defendant?
Yes, and my understanding of the basis for restitution here is that had Dr. Ozan disclosed Marco Moran's fraud to law enforcement and TRICARE, then the federal government would not have paid Marco Moran $116,000 and change during the period from March to May 2014. So the restitution was consistent with the statute. It was a causation analysis where Dr. Ozan's failure to disclose led to that loss in the
But the direct and proximate cause has to be the criminal behavior, criminal conduct of the defendant, does it not?
Yes, and that's what I just said. The theory is that had Dr. Ozan disclosed to law enforcement, the federal government would not have paid Marco Moran's pharmacy $116,000.
Have you researched whether the Fifth Circuit agrees that a federal court can order restitution under this statute for the criminal conduct of another person?
Under my testimony, it's not ordering restitution based on the criminal conduct of another individual. It's ordering restitution based on the fact that Dr. Ozan's non-disclosure led to a loss amount to the government of $116,000 in change.
I apologize, but I don't think you answered your question. I answered my question. I didn't ask it right. You say that the theory, your understanding of the basis of restitution is Marco Moran's fraudulent scheme, the paying premium, correct?
That's correct.
Under this statute, the federal judge cannot lawfully order a criminal defendant, in this case, Dr. Ozen, to pay restitution unless the court finds that it is Dr. Ozen, this defendant's criminal conduct that caused the injury. Is that not correct?
That's correct. And as I explained previously, it's a causation standard. So the theory of the federal government, the understanding of the restitution statute was that by not disclosing to law enforcement and TRICARE, Marco Moran's fraud, Dr. Ozan caused the federal government to pay $116,000 in benefits that it otherwise wouldn't have paid. That was the basis for restitution. The two are intertwined in my opinion. I understand your point, but I hope you can see mine.
Certainly, I can understand that. We discussed with opposing counsel, the extent of the research concerning, issues including malls. Fair.
Yes, that was part of our research because it's part of the standard by which a licensing board would revoke a medical license.
And, you didn't say that no medical board has ever disciplined a doctor for a violation of this particular misdemeanor statute. You said we need to find it. Is that right?
That's correct, because if a decision was not reported in the database, it wouldn't show up in the results of my research and my colleagues' research. We only know what we know. We don't know what we get.
Understood. And I'm asking this, I'm breaking the cardinal rule of the talk about. What states are decisions of medical board reported? Let me rephrase. In the Westlaw database that and that we basically research. Can you tell the board what states' decisions are contained in that database?
I cannot here today tell you which board's decisions are in the Westlaw database. I can only tell you that we researched the database. I should also note that in addition to researching the Westlaw database, we also reviewed board decisions that were posted on Mississippi Board's website covering an expanded, I think at least 3 years to see if we can identify anything that might not have been transferred to Westlaw.
But your research, as I understand the results of the report, were based on the fact that you did not find any instances where this particular misdemeanor statute 1320A-7B subparagraph A3 had been the basis for discipline. Is that correct?
That is correct.
This misdemeanor statute is not the only statute or offense. This misdemeanor offense, that's not the only offense that can constitute a crime of moral turpitude.
Well, I don't think this misdemeanor offense, as related to Dr. Roseanne, but guilty to it would constitute a crime of moral turpitude. But yes, there are other crimes that could constitute a crime of moral turpitude. We researched some of those. They're not relevant to this proceeding, but as part of plea negotiations, we were always carefully considering potential charges, whether they could fit actually under the circumstances and whether or not they would constitute a crime of moral turpitude or not. based on our research.
What types of jewelry are displayed would be considered, could be considered crimes of moral turpitude?
My understanding of a crime of moral turpitude is it's essentially a repugnant moral behavior. And I think you referred to some of these in your opening, including child abuse, rape, things of that nature. It can also take into account theft or fraud.
And,
Yes,
perjury,
yes,
obtaining money or goods under false pretense,
I would think that would qualify, yes,
bribe,
yes,
theft.
yes.
I probably wouldn't say that. Money,
I would think so, yes.
I'm assuming that you have read the case about the body camps in Montalvo, the Mississippi State Court of Medical Rights.
We read several decisions that were reported up to Mississippi courts as it related to defining crimes of moral turpitude. The name sounds familiar, but I will confess that I don't recall that specific case.
Okay. Well, and I want to make sure that the record is clear. The statute of Montalvo is discussed. Which is Mississippi Code annotated section 99-1935. We're not asserting that that statute directly applies to that code.
That's correct. That's a mandatory, as I understand it, that's a mandatory suspension. The board would have no discretion if that statute were invoked and if you committed a crime for that statute.
And in fact, that statute actually does. That's right.
Yes, can we take a 10-minute break then? Thank you.
Yeah.
Absolutely. Thank you.
Apologize for retracing the ground. You know, I was focused in, I'm really focused. Okay. So, I was about to discuss the rest of the questions about the statute. This because 1935. And I believe you had testified, and we agree that the statute doesn't directly apply because that statute, is absolute mandatory, suspension statute. Is that right?
Yes, I think that's a summary of my testimony and here.
In fact, it's a little more than that, isn't it? That statute says that a position that no one convicted of one of the crimes listed in that statute can ever practice medicine unless they're part. Is that right?
Yes, that's my understanding.
So the portion of the, and that was right there, the short statute. It's entitled person convicted of certain crimes not to practice medicine in history or on the office. It reads a person convicted of bribery, burglary, theft, arson, obtaining money or goods under false pretenses, perjury, forgery, embezzlement, or bigamy. Shall not be allowed to practice medicine or dentistry or be appointed to hold or perform the duties of any office of profit, trust, or honor unless after full employment is discerned. I'm sorry, that's on MSB 124 in the copy. I believe that's correct, but it is in the record. So that's what I wanted to ask you about the Montalvo case also. In our exhibits. May not have. I didn't, if I didn't, I'll just read it over.
Any objection?
For the record, cases Montalvo versus Mississippi State Board of Medical Licensure. 671, 7-2, 52. I'm gonna do, so let me go to a different line of questions while we get, I don't have a copy of the witness. I apologize. Present at the James Cleveland,
I was not.
President Simpson,
I was not.
he does training.
Yes.
It's just that it's present at the Senate, so it's in the change of president.
Can you correct it? These forms, neither of those transcripts. The Dr. Ozan directly denies that he is involved in this.
No, but you won't be able to direct me to unfortunately where Dr. Osman says that we have fraudulent effects because the factual basis doesn't include that.
One of the essential elements of the file.
Yes, although there is some confusion on whose intent that is. Yes, I understood the factual basis that we put forward, it was very clear that we were talking about Marco Moran's fraud, which Dr. Paulson thinks to disclose.
Yeah, I want to be absolutely sure that I'm saying this. Use your testimony. If under 42 USC 1328-17A3. That the essential element quote, with an intent fraudulently to secure a benefit or payment. That language can refer to someone other than the defendant who is pleading guilty to that. Is that your testimony?
My testimony is that the statute is confusing as to who's intent. And as respect to the factual basis for the crime, Dr. Ozan does not say that he had fraudulent intent. It speaks of knowledge of Moran's scheme, excuse me, and I'm finishing my statement, please. And as a result of the fraudulent prescriptions that Moran submitted.
Sorry, yeah. Well, did your understanding? What's your understanding of the time as an addict? When Dr. Ozan could plead guilty to this crime based on fraudulent intent. Is that correct?
Yes, and it's not just my understanding, but it's my I guess, factual belief based on how the change of plea was accepted by Judge Sarah, that was in fact the case. Because after reading the elements, the factual basis was read in. It did not include any fraudulent intent on Dr. Ozan's part, and Judge Sarah accepted that factual basis as a sufficient predicate for finding Dr. Ozan guilty of the crime that's charged.
So why was all this discussion about whether he actively concealed anything? Because I don't see whether actively or passively concealing it makes him get a trial.
Because it mattered to, my understanding is because it mattered to Dr. Ozan. He did not actively conceal anything, and in his mind, as I understand it, that matters. He did not mean to conceal anything, that his understanding of what he did was fail to disclose when never did disclose.
Did Dr. Ozan contact the hospital, or the hospital first, or did someone at the hospital come to him?
I don't recall.
And can we mark this as MSB, I guess, 000132?
Thank
Thank you.
What's being distributed is the Montalvo case that I referred to earlier.
I'm running out. Jackie, I need a couple more.
Two copies.
To
While we're waiting for copies, that's in the, since I've asked. Should we wait for this time?
Do you have any other questions you'd like to ask me before we get to the point?
Um. Sorry, right, you have a copy of my free page, right? I do, yes, okay. And looking on page 4 of 6, the first paragraph states that pursuant to this code annotation, annotated in section 73, 25, 29, 6, provides for the suspension or revocation of medical licensing within a licensing for conviction for a felony or misdemeanor involving moral turpitude. State Board of Medical License suspended on Southeast license on January 15, 87. Okay. So Dr. Montalvo had been suspended by the bench in this case. And then he asked to be reinstated.
That's my understanding. Yes.
And yeah, based on we have someone here today. We have some to bring someone in with personal knowledge of the case, but he's not here today. Based on the reported decision. On page 5 of 6, in the second column, first and fourth paragraph, where it says the record indicates that the board was presented with and considered evidence of Dr. Montalvo's character, professional abilities, and activities both before and after his conviction. He, however, was convicted of a felony involving moral turpitude. Moreover, this code annotated section 99-1935 provides that, and then if they read the statute that I've already read for the record, a person convicted of these listed crimes, bribery, burglary, theft, arson, obtaining money to goods under false pretenses, perjury, forgery, embezzlement or bigamy, shall not be allowed to practice medicine, dentistry, or be appointed to hold the appointed duties of any office of profit, trust, or honor, unless after full pardon for the same. Then the court goes on to say, and because this was Dr. Montalvo's time, the crime of committing fraud against the federal government through money laundering is analogous to the enumerated crimes above, which adds to the full pardon forever bar Dr. Dennis from again practicing his profession. Especially given this statutory directive, it cannot be said that the board's decision was arbitrary and capricious. So at least in this case, the Michigan Supreme Court said that the crime of money laundering was a crime of moral turpitude. Correct?
Yes.
And again, make absolutely sure that I understand the question. Judge Sterry, in your understanding, and reading this, that you're not present here, accepted Dr. Ozan's guilty plea, despite the fact that Dr. Ozan himself did not have fraudulent intent.
That's my understanding. Yes.
Did Dr. Ozan say, I do not have fraudulent intent, or words to that effect?
No, I don't think we needed to, because he also didn't say he would have fraudulent.
Yeah, just so the record's clear, you were an advocate for Dr. Ozan. Correct?
Yes.
Testimony is based on your understanding, research, and your role as an advocate for Dr. Ozan during that time period. Correct?
That's correct.
You had a chance to look at the Mentaldo?
Yes, and I will say that I did read this decision when we were.
It's pretty context. Mentaldo, 40 to 30-year money laundering conviction felony, correct? Ringo's in Michigan. Mentaldo was tried and convicted by a jury. Is that right?
I don't know if it says he was convicted by a jury, but yes, he was convicted of conspiracy to defraud the United States, and the opinion refers to his participation in the laundering of drug money.
Drug trafficking, money laundering felonies, convicted by a jury, sentenced to prison. Went to prison for, was sentenced by the judge to 5 years in prison. What is it?
Yes, he received a 5-year prison sentence.
The route that's wholly different from what we were dealing with here today.
Yes.
Any further questions?
Recall. When a defendant pleads guilty to a crime, is that a conviction?
Yes.
Any questions from the board?
We're dealing with three different entities as far as businesses. One of them is Custom Pharmaceuticals, is that correct?
Custom Care Pharmacy.
Custom Care. The other is a hospital. What hospital is that?
Rush Memorial Hospital.
Okay, Rush. And the other is a pharmacy. Is that within the hospital?
I believe the other pharmacy you might be referring to is RX Menus.
Okay, so is that different than the hospital?
From Rush.
Okay, so we got three different hospitals. Ms. Wolf. She's a nurse and she's a quote administrator, but what is she the administrator of?
I'm sorry, which was the name? I just want to.
Ms. Wolf.
I don't
Okay,
believe she was with Rush.
she was with the hospital, so it was probably Rush. Did the hospital, the independent pharmacy, and custom care pharmaceuticals have any policies or procedures concerning compliance and reporting?
The hospital had compliance procedures. I don't know.
Okay, but we don't have that today.
Not that I know.
Okay. And it seems to me that if you were going to report something, you would report it to the entity you were involved in, and then that would go up the ladder. Can you report it just anywhere?
What was the last part of the question? I'm so sorry.
I said, can you report it just anywhere? Like if you're in custom care pharmaceuticals, can you go across the street and report it to a pharmacy?
Wouldn't think so, no. I mean, I understood that Dr. Ozan was an employee at the time of Rush Hospital, and he reported it to Rush Hospital's compliance. And as I understand it, we also confronted one of the pharmacists.
Okay, so does Rush does Rush Hospital have an obligation to report something up the line that's not part of Rush Hospital? It's part of custom care pharmaceuticals.
No, I don't know.
Okay. The other question I got is, I'm hazy on the 116,000. When I first started listening to this, I was under the impression that the defendant got the 116,000. Then I was under the impression that no, he didn't. That was a computation done by the feds that it cost him this much money, so that's what he owed. If not, who got the money? And am I wrong in assuming it was a computation by the feds?
Yes, so my understanding of restitution, as I was testifying with board counsel, is that it's based on a causation standard. So if the defendant, in this case, Dr. Ozan, caused a loss, then he would be responsible for making restitution. In this case, TRICARE. Because Dr. Ozan failed to disclose to law enforcement Marco Moran's fraud, he satisfied the definition of helping to cause that loss to TRICARE, and so he made restitution to make them whole. But that does not indicate that Dr. Ozan received that $116,000.
So nobody that represents him, wife, family member, whatever, got that money.
That's correct.
Okay.
Dr. Ozan had a $40,000 investment in custom care. As I understand it, after confronting Marco Moran, he asked to be bought out of the business, and Marco Moran returned his $40,000. Did not give him profits. He also paid him a consulting fee for consulting services that Dr. Ozan performed for Marco Moran. That was the sum total of their relationship.
So I just wanted to clear all that up.
When did that vesting set of his interest in the pharmacy?
Don't recall precisely. It was sometime in May, June or July of 2013. It was somewhere around the same time that he spoke with the Rush Hospital administrators. He also demanded to get out of business with Marco. But I don't know the exact things that I read.
Is it 2014 or 15?
14.
I just want to remind you too that you have a purpose of witness, so you may have an opportunity to answer questions directly to the individual as opposed to asking to a person who is not directly involved in those factual questions.
Any other question at this point? I'm sorry, see, we can't.
Take the.
Right. At this time, we are going to break for lunch. We would ask that we be back at 12:45. And I believe the responding council will eat first, get their food first.
Don't fix it.
Okay, thank you.
12:45.
So we'll be recessed until 12:45. Thank you. back in session.
Ma'am, so.
Yeah.
At this time, complaint counsel and the finance counsel jointly request that the board, go into recess of this disciplinary hearing in order to consider, a proposal. That is recess for executive session. Recess.
Reset.
This is the hearing and then go to.
Is there a motion?
Well, before we do that, I'd like to procedurally just read a couple of things into the record. Of course, this proposed agreement shall be at the subject and approval of the board. And if the board fails to approve this proposed agreement in whole or in part, it shall have no force or effect on the parties. It is further understood and agreed that the purpose of this agreement would be to resolve the current hearing before the board. In this regard, the licensee authorizes the board to review and examine any documentary evidence or material concerning the licensee prior to or in conjunction with its consideration of this agreement. Should this agreement not be accepted by the board, it is agreed that presentation to and consideration of this agreement and any other documents and matters pertaining thereto by this board shall not unfairly or illegally prejudice the board or any of its members from participation in any further proceedings. So if you all do not come to an agreement regarding the terms and conditions of their proposed agreement, you will not be disqualified from continuing on with the hearing.
That is my understanding.
Yes, that's my understanding.
Thank you.
A motion,
Please.
make a motion to recess to consider the proposal.
So,
Okay, so it's been moved and properly seconded. Any further discussion? All in favor?
Aye.
Any opposed? Any abstentions? Okay, in that case, we are extended in recess.
Do we need
All in favor?
Aye.
Any opposed? Abstentions? All right,
So procedurally, we recess the hearing, but the meeting is to the lunch. So if y'all want to take a break, that's fine. But we are in closed session at this point. We're in closed session.
the
We're in
hearing
closed
was
session.
recessed, but not
Gonna go consider a motion whether to go with
May,
Yes,
may I request that the board permit me and counsel for the licensing to participate in the executive session?
when we
reset.
go in, when we go into it,
We got,
you have to get there first.
we're not there yet.
The other thing we could do is, we could just continue this, allow us to get this public, hearing, and then allow the board to go into executive session to consider.
Whatever you want to do. We're already in
We're in
closed
closed
session.
session right now.
So we'll,
Let's just keep going.
yes,
It's not my money.
absolutely.
I think she's.
And I'm back in open session, and Dr. Tom Joyner, our secretary, will give the decision of the executive session.
Thank you. In the executive session, we discussed the matter and we made the decision. Number one, place your license on probation. Notice I said probation, not suspension, but probation, to run concurrently with the feds. Number two, you do not have to reappear in person. At the end of this probation, your lawyers can do it for you. And number three, you need to reimburse the board for our investigative costs.
If there are any additional stipulations that were discussed in executive session, I'd like for those to also be read into the record at this time.
The final terms and conditions will be placed in a consent agreement for signature and review. That's okay.
So at this point, then this matter is adjourned. Thank
Thank
you.
you.
Thank you.
Thank you. Thank you.
All right. So the next item on our agenda is gonna be
Next board day.
next board meeting. So, yeah, so this is I know, church time, right? So looking to November, the expected dates would be, because of the Thanksgiving holiday, of course, November 16th and November 15th and 16th, the Wednesday and Thursday, third Wednesday and Thursday of November. That works?
What was it again?
What?
What day was it? I'm sorry.
You again? No. 15th and 16th.
I will probably be in. Yes.
It's about that time.
Yeah.
I'm sorry.
So, Dr. Gibbons,
May I be excused?
I take it that you are not going to be able to join us on that day.
That's good.
And I do believe from earlier business that we are anticipating a hearing to be at least one hearing, which may be a bit lengthy to be held during that board meeting. So I do kind of need to get a feel for everyone's availability.
I can be available remote.
I will probably be available like I was this time, Wednesday morning and then all day Thursday. Wednesday afternoon, I think that's it.
So that's two, and then we'll see what gets out from the available. Logan says that works for him.
If there's a chance for a remote join, if I end up having some surgery, like the couple of days leading up to that, I might need to do that.
So
Is that what you're asking?
that's,
Yeah, I know it's a pain, but so will having my foot delayed open. I'm gonna be all jacked up on hydrocodone anyway, so I don't know if I'm gonna really help. I might need
I wouldn't
to.
say that right now.
Yeah.
Okay, so, yes,
Right.
let's please, yeah. There. To all the people on Zoom. So potentially, potential option for virtual could be there if we need, if necessary. Okay. And hopefully we'll be able to work it out so that there's a form without it. So we'll send out a confirmatory email to get everybody's like card RSVPs? Okay, so keep your eyes peeled for the email so that we can determine availability because our body count is gonna be important. Okay. Anything else? Any new business or other business? Hearing none, I will entertain a motion to adjourn.
So moved.
Second.
We don't have to vote on that one. All right, so we are adjourned.